topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show, where we bring you the finest experts in the field of legal, health, financial, and home improvement. Since we have sort of what you would call an older audience, which I love because I'm older, one of the most important shows we do is on estate planning. And from your letters, we have found that many people have not even gone to see an attorney and done their estate planning. So we brought you one of the top attorneys in the state of Florida, attorney Tom Olson with Florida Senior Planning. And I got to tell you, looking at the numbers from our YouTube, people really love this show. We have a lot of 50-minute long shows, but we decided to break this one up into 25-minute shows so we could catch more of you. Let me introduce you to one of the greatest estate planning attorneys in the state of Florida, attorney Tom Olson. Good afternoon, Tom.
Good afternoon, Steve, and all of your loyal listeners in South Florida.
Well, I got to tell you, they're getting pretty loyal to your show looking at the YouTube numbers. Tom, I got to tell you, we are so lucky to have an estate planning firm like yours because there's so much that people don't understand when it comes to estate planning. Listen, we saw where Prince didn't even have a will, and he's got all these managers supposedly taking care of his business. There's so many people out there who don't even have a simple will or a trust plan. And this show is to educate people. Tell people about your firm, first of all, Florida Senior Planning.
Well, Steve, one of my favorite sayings is that there is no substitution for experience. I've been doing estate planning for people here in Florida for 45 years. I've done thousands and thousands of wills and trusts. Here at FloridaSeniorPlanning.com, we know how to make the process very simple and easy for people. We offer a free initial consultation to talk about your estate planning. We can do that in person, over the phone, via Zoom. We know how to make the process very simple for people out there, Steve. Basically, to do estate planning for people, generally there's three things we need to know. Number one, who's going to inherit your wealth when you pass away? Often that's simple. If you've got 3 kids, most people would say, I want to split everything equally between our 3 kids. Number 2, who would make healthcare decisions for you if you're not able to? If you're married, you and your spouse are each other's first choice. Then you're choosing your children for a second and third or fourth choice. And then number 3, who's going to take care of business for you if you're not able to? And all very important documents for you, Steve, your listener, Steve. When we do estate planning for people, we do 4 basic documents, FloridaSeniorPlanning.com. We do a will. We do a living will declaration where you ask that you not be kept alive by machines. We do a healthcare surrogate. So if you're not able to, you're appointing somebody to decide what doctors, what hospitals, what medications. And we do a financial power of attorney. So if you're not able to, you're appointing somebody to pay your bills and manage your financial affairs. Check us out. Give us a call, floridaseniorplanning.com. We assist people throughout the state of Florida. Wherever you are, we can help you.
Hey, Tom, we got a text right before the show. A person wanting to know, do you think it's a good idea to let their local hospital know their contacts? He said, from what I understand, hospitals have a library of people's names. And have you heard of that before?
Steve, I know that whenever you check into a hospital, standard procedure, they're going to ask you if you have a living will. And usually they're going to ask you, do you have a healthcare surrogate form? And these are things that they want to have on file for you just in case they're needed. So, by the way, when we do estate planning for people, we put everything in a notebook, nice and organized for you, easy to keep track of. And then we scan everything for our files. And then we put a scanned copy of everything on a thumb drive for people. So it'd be very easy for you to share copies of these healthcare surrogate and living will forms with your primary physician and with any doctors or other hospitals that you do business with.
The same person just rewrote us. So we want to know, what if you're unconscious when you come into the hospital?
Well, hopefully they're going to find out who you are. They're going to contact your loved ones and next of kin, and hopefully they're going to know that you have these documents. Okay. When we do these documents for clients, we say, look, here's your 3-wing bind notebook. Here's your thumb drive with a copy of everything on it. Whoever you have chosen to take care of business for you or make healthcare decisions for you, you should send a copy of these scanned documents to that person. So they'll have a copy of them. They'll know that you have them. They'll know what they say, and let them know where you're going to keep this 3-wing binder. And so it'll be easy for them to find it if they need it.
Tom, it's kind of, I don't know if it's a morbid subject or not, but every time I see of a young person passing away, young person meaning 30s or 40s or 50s, I always wonder if they put just a simple will or trust together, because listen, we never know. I mean, we're kind of on a day-to-day basis, and it's so important that people get in to see you, no matter what age they are.
Well, it is, Steve. And by the way, this is a busy time of year for us. Sometimes we have clients who give a gift of estate planning to their children, their adult children, so that they come down, they buy a gift certificate from floridaseniorplanning.com to give to their adult children. Wow. And then once January starts, it's often on people's New Year resolution. This is the year, this is the time I'm going to get my estate planning in order. And people might say, what's so important about it? Well, I can say this, Steve, that when we're done signing estate planning documents with our clients, we'll walk them to the front door, and often they'll say a couple of things. Number one, hey, that was easy. Hey, we know how to make the process simple for people. And then number two, they'll say, that is such a burden off my shoulders that I finally got that done. Now, Steve, when we talk about people in their 30s and 40s, and hey, they're still the age where they think they're going to live forever, but let's assume that they've got young kids, 5, 10, 15 years old. It is doubly important that they have their estate planning done, because you can't leave your money and your wealth, your life insurance, IRAs, cash, and home to minor age kids that are under the age of 18. So they would be candidates for a revocable living trust. That trust would state that if mom and dad both passed away, their wealth would go into this trust for the benefit of their minor children. They would appoint a successor trustee, typically one of their brothers or sisters, adult relative. And that person would manage this money on behalf of the minor children. They would use that money to help them go to college, help them buy a car, help them buy a new home. And then the trust dictates at what age their children would get this money. Typically, we recommend age 25. So prior to the children reaching age 25, the money's being used to help them go to college, etc. And then it says that once they reach age 25, whatever's left over of that child's share goes to that child outright and free of trust. Now, Steve, let's say that somebody doesn't take that advice, and we strongly recommend you do it if you got minor kids. What happens if mom or dad passes away and they've got minor children? Well, the problem is that the law is going to require that a legal guardianship be set up for those minor children to receive their parents' money. We don't know who the judge is going to appoint as a guardian over that money. It might be one of your relatives that you don't like, or it might be a complete stranger. But the worst thing is that the law would require, under a legal guardianship, that money be turned over to your children when they turn age 18. And as you can imagine, an 18-year-old is much too young to receive a bunch of your wealth, because guess what? They're going to buy a new car. They're not going to go to college. So when you do this trust that we recommend, you get to dictate at what age that money will go to your children. We usually start with age 25, but hey, sometimes we do half at 25, half at 30, knowing that they're going to blow the first half, but they'll be older and wiser when they get to second half at age 30 and do something better with the money. So these are all very important for people that are youngish, 30s, 40s, and have young kids to get their estate planning done.
This is from Christy in Boca. Thank you for bringing a show like this. I have a new business with a business partner. I don't want to have to worry about if my business partner passes away that I'm stuck with his wife as a partner.
Yeah.
What can I do? Ooh, that's a good question.
First of all, Steve, I want to remind your listeners that at FloridaSeniorPlanning.com, we have free booklets on all of these topics: living trusts, wills, how to avoid probate on your home. We would be happy to mail you those free booklets. And I'm going to suggest to your listeners that they call right now, because we have somebody standing by to take that request to get these free booklets in the mail to you right now at 407-423-5561. Or they can go through our website, FloridaSeniorPlanning.com. We'll get these free booklets out in the mail to you. For this texter, what they need, they own a business together. These are two unrelated people. They own a business together. They need a buy-sell agreement between them. And then they fund that with a first-to-die life insurance policy. So these co-owners of the business, they would agree. Let's say they agreed that if one of them passes away, their 1/2 share of this business is worth $500,000. They would sign a buy-sell agreement that says if owner A passes away, the spouse or heirs of owner A must sell that stock to owner B for $500,000. This first-to-die life insurance policy, the premium would be paid to owner B, and they would use that $500,000 life insurance to buy out the spouse or the heirs of owner A. So your texter is on the right track. They do need to be concerned about this issue. They would work a business law attorney for a buy-sell agreement and then buy a first-to-die life insurance policy to fund that buy-sell agreement.
You know, Tom, I don't know if you remember this, but one of the first things you and I talked about is what really impressed me about your firm. We were talking about probate, and you had shared with me that one of the things that you make sure that you do is try to keep your clients out of probate, because it can get really expensive. And that was one of the things that I really liked. I mean, hearing an attorney who you could make a lot of money off of say, you know what, I don't want you to have to go through probate, and we're going to set you up.
Steve, people are interested in avoiding probate because it's expensive and it takes a long time. Steve, without fail, when we talk to our clients, we include all the steps needed to avoid probate. When we speak those words to a new client, hey, we want to help you to avoid probate, you can see their ears perk up, because everybody, it seems, has a horror story about somebody that went through probate, their parents or their brothers or their sisters, and they know it's expensive and it takes a long time. So we help people to avoid probate, standard procedure. We have a free booklet on easy ways to avoid probate. We'll mail that to you. If you call us, we'll mail that booklet to you at 407-423-5561. As far as avoiding probate, some of that work to do that is done by Florida Senior Planning. Some of that work is done by the client. So, for example, it is easy to avoid probate on your bank accounts, checking, savings, CDs, money markets by making them POD, payable on death to your children. If you make your bank accounts POD for your kids and you pass away, the only thing they need to do is to show the bank or credit union or investment company your death certificate, and they will write checks to your kids, one check to each kid for their share of this POD account. To make your accounts POD, payable on death, you don't do that with me. You don't do that in the will. You do that at the bank or credit union or investment company. They'll give you a form to fill out. That's your homework. And by the way, when we do estate planning for people, they walk out with a one-page action plan. That one-page action plan tells them what we're going to do, floridaseniorplanning.com, and it tells them specifically what their homework is, including making their bank accounts POD. As far as the things that Florida Senior Planning will do, they include doing a ladybird deed. A ladybird deed is a tool to avoid probate on real estate that you own in Florida. Your home, your beach condo, your investment property, your vacant lot. Even if there's a mortgage on it, we can do a ladybird deed. That deed states that as long as you are alive, it is your property to do with as you please. But when you pass away, that property will automatically go to your children. No headaches, no hassles, no probate. Steve, I can't tell you over the years how many people have come to me or said to me, hey, Tom, I've got a will. It leaves everything to my 3 kids. When I pass away, doesn't everything automatically go to them? Because my will says it goes to them. No, it is not automatic. If you pass away with an asset in your name only, like a bank account or your home, it will require probate to get that asset out of your name and into the name of the kids. So there's nothing automatic about it. You need to take steps. You need to work with do your homework and work with floridaseniorplanning.com. We'll get that accomplished.
Here's a question from Christy in Delray Beach. She wants to know, do you handle guardianship? I only ask that because I have an autistic daughter, and when she turned 18, it was nightmares. I was so uneducated how the state kind of takes over. I should have definitely known I should have hired an attorney.
Yeah.
Do you handle guardianship?
Steve, I know about guardianships. I've done them early on in my career, but we don't do them anymore. At floridaseniorplanning.com, if we don't do that type of law, then we're going to try and find an attorney for you in your area that can do that for you. We don't do guardianships, but we refer them to other people. Steve, one of the things I wanted to say about avoiding probate is that I've been a lawyer for 45 years here in Florida, and I can say back in my early days, in the early 80s, when mom or dad passed away, rare was the day that the kids would argue and fight with each other. I got to say, these days, it is more common that when mom or dad passes away, they will argue and fight with each other over the estate. Sometimes they'll end up not even speaking to each other. Steve, if we take all steps necessary to avoid probate, we make things simple, easy, inexpensive for your kids. That means there is much less opportunity for them to argue with each other. So people might say, hey, Tom, you know what? I'll let my estate go through probate. I don't care. I'll pay a 3% fee to the attorney to go through probate. Well, the problem is that what I see in probate is that you have to name one of your children to be the executor of your estate. And it's like an opportunity for that one child to settle scores with all their siblings. And eventually with that probate, I'm going to get a call from one of those siblings and it's going like this. Steve, Tom, my mom died a year ago. My brother's the executor of the estate. I don't know what's going on. I haven't gotten any money. I haven't gotten an inventory. I don't know what's going on. Well, now they got to hire me to get the money that they're entitled to. So let's take steps to avoid probate. And that's going to be much more likely that when you pass away, your kids are not going to be arguing with each other. They're going to spend time grieving their mom and dad and being grateful for whatever it is that they happen to inherit from mom or dad.
Tom, this is a question from Miami. Rex in Miami. I'll bet you this is a question you get all the time. My father disinherited me, took me out of the will. Do I have any recourse to get any of the funds that were divvied out?
So, Steve, that is a common issue and a common concern. Steve, when we occasionally do wills and estate planning for people where they've got 3 kids and they want to omit one of them, and that situation here at FloridaSeniorPlanning.com, we take very good notes about why the parent did that. Often it's going to be something like, hey, I loaned that child money and they never paid me back. Or, hey, I co-signed a car loan for them and they quit making payments and I got stuck with a loan. Or maybe I gave that child money during their lifetime. So when that child goes to an attorney and says, hey, mom or dad cut me out of their will, I want to sue, I want my share, and that lawyer contacts us, Florida Senior Planning, we have notes and reasons why mom or dad cut them out of the will. And it usually does not go any further than that. But let's just say this, that if mom or dad passes away and, hey, the daughter was living with mom and dad and taking care of mom or dad, and, hey, guess what? Mom and dad left everything to the daughter that was living with them. Hey, there's every chance that there was some kind of undue influence going on there, and it might very well be looking at. If that daughter prepared mom and dad's will and the daughter's friends witnessed and notarized that will, it is automatically suspect. So for this texter, Steve, I'm going to say, hey, don't give up hope. Step number 1, I think, is to get a copy of that will. If it's a handwritten hot mess, you might very well be changing it and challenging it. If it was prepared by an attorney and witnessed and notarized by the attorney, it's probably rock solid.
Wow. Tom, I wanted to, we've got a couple minutes left. I want you just to tell people within the next, I guess, minute, why they should hire you.
Steve,
even if they don't think they have any assets.
We have been doing this for a long time, Steve. We know how to do this. We know how to make it simple for people at Florida Senior Planning. Everything we do on a flat fee basis. So you come to us, together we'll come up with an action plan. Once we agree on an action plan, we'll quote you a flat fee. Steve, we talked about doing the 4 documents: will, living will, healthcare surrogate, financial power of attorney. To do those 4 documents for a single person, it's only $900. To do those 4 documents for a married couple, 4 for him, 4 for her, it's only $1,100. To do the Ladybird deed, it's only $850. That is going to be the best money you have ever spent to avoid probate, make things simple, easy, inexpensive for your kids, so that when you pass away, they're not going to have an opportunity or a reason to argue with each other. And that's so important to parents.
The name of the firm is Florida Senior Planning. Tom, tell people how they can reach you, especially those who are listening on radio, on iHeart, Spotify, who can't see. We're running a scroll now. Give them your phone number and your website.
FloridaSeniorPlanning.com. We assist people anywhere in the state of Florida, from Key West to Pensacola. We can assist you, and you can call us at 407-423-5561. Remember, we've got all these free booklets: Easy Ways to Avoid Probate, 6 Reasons Not to Die Without a Will, booklets on living trusts, how to avoid probate on your home. We'll mail those free booklets to you, but you got to let us know your name and mailing address. FloridaSeniorPlanning.com, 407-423-5561.
Tom, Tom's with us twice a month. He'll be back again with us next month. Tom, have a wonderful holiday. We so appreciate your firm, and we'll see you next year.
Okay, Steve. Bye-bye.
Thanks, buddy. That's attorney Tom Olson of the Florida Senior Planning, PA. We're going to go to break. We'll be right back.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.